Jeremiah here, and it's Thursday on week 2 of the Allard trial here in Vancouver. We've just wrapped it up. I'm with John Conroy, the lead lawyer in the case. John, how you doing? Good to see you.
Good, thank you, Jeremiah.
Good to have you here on POT TV. And John, I haven't had the chance to really talk to you about the case yet on camera since it's been going. I wanted to ask you first about last week and how you thought we did, our witnesses did, in front of the Crown.
Well, I think the plaintiff patients who came forward and gave their evidence, they were, I thought, exceptional. They really, you know, I think made it clear to the court what they're going through, and I thought they gave very good evidence, and I hope that Justice Phelan feels the same way about it. I think the experts that we had, Ramo, you know, they tried to make much of Ramo's advocacy and some of his jokes and so on, but at the end of the day, he's talking about equipment that exists in order to enable people to do this safely and securely, including devices that you can just plug in like a dryer, you know, for people in condos and small spaces and
Grow
so on.
boxes,
So
we're talking
there is an engineered solution, you know. I'm fully sympathetic to all of those people out there who are upset because they're stinking out the neighborhood and they're having a problem, or they're fearing that there's a fire, or they're fearing that there's electricity issues. So you got all these people who know nothing about this, who only hear these emotional scare things in the media, who need to be assured that there is equipment. There are most of these lawful growers, you know, get permitted, do have inspections, do make sure that it's safe. They don't want to have problems, not only for anybody else, but obviously for themselves. They are not people who are in the business of trying to sell a product to the public. And there's a huge difference. If you're trying to sell it to the public, obviously you have to meet all kinds of requirements in order to make sure you're not, you know, going to cause harm to the public. If you're doing it for yourself, it's assumed that you will do everything you can to try and not harm yourself.
Right.
So I think that Ramo, David Pate, Dr. Pate, in terms of the extracts issue, or just simply explaining the whole, you know, more recent evidence and everything with respect to cannabis. Zachary Walsh, in terms of the demographics, to show that a lot of the people who are patients are on disability pensions, and affordability is a big issue. And that's a major factor that the government, while aware of, appears not to have, well, hasn't done anything to ensure that those people would be covered. Mm-hmm. And so I think that's an important part of our case, and I think a weakness in their case. So, you know, who am I forgetting? Ramo, David Pate, Zachary Walsh.
And we had Tanya Beamish was not able to actually make it into
of the actual plaintiffs, because
right.
She was back in hospital.
Right, but her husband was able to speak on her behalf.
That's right, and I thought, you know, it was, I think we gave the court a good set of examples of the different types of things that can arise from a basement to an outbuilding in the farmland, to
right.
people helping each other who are patients, to people who are the spouse helping the wife, or the individual guy, to try and make sure the court, you know, has the variables that commonly arise. I'm sure there's more, but enough to ground a constitutional challenge, which is what this is. A lot of people think it's a class action. It does represent a large class,
right.
Everybody who's medically approved, and people, you know, they wonder what the impact will be for them, and it will depend upon what Justice Phelan ultimately decides. But as I've said, you don't want to expect that he's going to legislate. He's not going to say, here are the provisions. I mean, he may do some interim thing, hopefully, if he agrees with us. He'll do some interim thing pending having the government legislate, because that's their job. They have to, we're saying these regulations are deficient, the new regulations failing to allow people to continue to grow for themselves or have a caregiver do so. So that has to be put into the MMPR. If he agrees with us, he'll have to do something, we hope, interimly about that, while allowing the government a period of time to frame it properly in the legislation.
Right.
Same thing with the under 50-gram limit, the extracts issue, dried marijuana limit, that
Right.
sort of thing.
That you're challenging now, but it would be up to the government ultimately to come back with a new set of regulations that would replace the MMPR in some way, you know, at some point.
Well, that whole issue is probably going to arise in the Smith case, which is going to be heard on March 20th in the Supreme Court of Canada, which is the case that Kirk Tousaw is counsel. I'm going to go carry his bags for him. And
Nice.
You know, we think that the Smith case, being about the limit to dried marijuana, it's a Section 7 charter issue, Section 1 charter issue. For your listeners, what that basically means is, you know, we're fortunate to live in Canada, which is a first world country that has a constitutional democracy. We're not here at the whim of politicians or others. We have this law, which is the supreme law. We have the independent courts that interpret it, and they keep the politicians and other emotional reaction type folks in order when they, you know, go too far, when they do things that are inconsistent with what the legislation provides, when they cause horrible effects to people. And so we're lucky to have this Constitution and this Charter so that we can go to a court of law and say, hey, look what the government's doing. We say, this is unconstitutional. You are doing this in a manner that affects all these people in this way, and what you're really trying to do is you're trying to limit their ability to do what they've been doing now for some 14 years. And you have to justify, under the Constitution, whether or not that limit is reasonable and justifiable in a free and democratic society. That's not an easy test to meet, and they bear the burden of proof. And I think from the comments of Justice Phelan so far, and you know, we've raised this before him in meetings of pre-trial and so on, Section 7 and Section 1. It's very important to assess all this evidence, bearing in mind those issues. We have the burden of establishing the Section 7 violation, and we submit we have.
Yeah.
They have the burden of justifying any reasonable limits on the Section 7 violation.
Right.
It's very difficult under our jurisprudence to limit a Section 7 right, because Section 7 is the broad right, and they often say other sections of the Charter are mere examples of Section 7 breaches, unreasonable search and seizure, arbitrary detention, these sorts of things. This one is liberty and the security of your person. It's actually life, liberty, and the security of your person, and the right not to be deprived of those things except in accordance with something called the principles of fundamental justice. And those have been developed by the courts now since 1982, when we got our entrenched Constitution, and they include, applicable to this case, arbitrariness, which is briefly doing something inconsistently with the purposes of the statute. Here, the Controlled Drugs and Substances Act, Food and Drug Act, and so on. Going too far, going further than necessary, overbreadth it's called, overbroad. So, you know, is it really necessary to eliminate personal production or caregiver production in order to achieve what they are trying to justify as reasonable limits? And so hence the evidence of the inspection ability, people getting permits, doing it all properly and safely and so on, you know, answers the complaints, we say, because they have to justify taking it away completely.
Right.
So that's what's in the balance there on the Section 1.
Right, but first, of course, the Section 7 part that you have to show first is that these patients are actually having to choose between their liberty or health, their health and their liberty, because if they have, you know, if they have to grow it on their own to get the medicine that they need, that puts them at a risk of arrest.
We have to establish, and I think we have, that any medically approved patient is, or I should say all medically approved patients are not covered by this government new regime. And they, we argue, knew it. They had people who couldn't afford the prairie plant system $5 a gram, which was 50% subsidized, and they're trying to collect.
Yeah, their accounts are in arrears.
And they didn't provide to cover. They took away the subsidy. They made it worse.
Yeah, doubled it.
Their own cost-benefit analysis predicted really a no net benefit of the different systems according to all the jargon of the analysis, but essentially one clear thing that runs throughout is the price, that the only people who would be negatively impacted by the new regime were the patients who would have to pay more. Everybody else would benefit. So, you know, again, you plug that into the constitutional framework, but, you know, I think the evidence is pretty interesting, and you know, we know next week we'll have some more witnesses, the international law experts from Israel and the Netherlands and the USA, as well as cross-examination of a couple of our rebuttal experts, Tim Moon, the fire chief from Alberta, and also
Len Garris is coming in on Monday.
Len Garris is Monday, who's still one of their witnesses.
One of theirs, yeah.
And we also have Mr. Wilkins, the insurance person from the island, who's one of our rebuttal expert witnesses in terms of insurance risk. And Eric Nash, in his capacity, well, both as the expert and fact witness. His fact stuff has sort of been canvassed the bidding court already, dealing with his experiences of trying to become an LP. But his expert witness stuff is further rebuttal to Garris and Holmquist and others in relation to all these problems that they say exist. Right. And so it just strikes us that, and it has for a long time, that you know, there have been serious problems as a result of illegal grow-ups, where people cut corners and did take risks simply to try and make more money and shipping it all down into the U.S. But the situation has changed. Colorado, Washington State, Alaska, Oregon, this has had a huge impact on the Canadian market, which was 80% of our market, and it's disappeared. And so, you know, all these illegal grows, huge numbers of them have closed up. Sure, there are people abusing it behind the MMAR and maybe the MMPR, you know, but certainly...
not that there's any evidence of that.
Well, if there is evidence, it's evidence that's very small, it's very little.
Right.
It isn't...
anecdotal as well, there's no statistical evidence.
Yeah, so, you know, that's the evidence. I mean, the facts at the end of the day, we'll see.
Well, and
you know, change.
I wanted to get
Garris is the only government witness left is Garris, and that's all to do with fire, and he may attempt to give evidence and beyond that, but we say that his expertise is in that area, or he has some expertise in that area. And
I wanted to get into some of the what happened with some of the witnesses this week, but I just wanted to quickly mention, you mentioned Remo and his testimony last week. One of the funnier things that stood out was, well, it was cool to see the Bloom box actually in the courtroom. I don't know if I've seen that before. Has that been done? Have you guys brought a Bloom box
I
in
mean,
the courtroom?
you know, it's a thing that can happen in court where you either the court goes out to take a view, or you bring something in and do a demonstration. And it just seemed to us that, you know, their expert talked about requiring an engineered solution, and that this was precisely that.
Right.
And so, you know, I'd never seen one before, and I was actually surprised at how big it was. I thought they were much smaller.
It was for 9 plants, the one that was there.
Yes.
Yeah.
It was 20, I think he said, on the one side, and 9 in the bigger part.
Right.
And but still quite a big thing. You know, you see these things for kitchens where you can do herbs and stuff, and I thought that you know, it would be much smaller, but at the same time, the plant's going to, I suppose, grow to a certain size. So I thought that was interesting, and it shows that there is an engineered device. And the Crown, you know, said, oh, well, you'd have to have 10 of these in order to produce your so many plants. When obviously, well, we submitted that, as the product said in its own background material that you could get what was it, a pound or something, a pound and a half or something every 6 to 8 weeks. And so, you know, our point was that you wouldn't need more than one. You could have so many crops in order to create a storage thing that you could then be satisfied that you have sufficient medicine that you produced for yourself under your control without having to worry about recalls and all those sorts of things.
Is there a danger? You know, is there a danger at all of the government coming back and then saying that you must use these grow boxes or something along those lines, rather than?
Well,
I mean, wouldn't that be unconstitutional in a way?
I don't know if I'd call that a danger. If the evidence is that by doing certain things in a certain way, you're putting your neighbors at risk or stinking them out, or you know, causing a nuisance to them, interfering with their enjoyment of their property, they have a legitimate beef.
Right.
And so if the solution is the Bloom box, to eliminate the complaints and the concerns and so on, there may be a reasonable argument for saying, and it would be a local government that I would expect that would do this by bylaw or something, that would say, look, if you're in a condo or if you're in an apartment, if you're in something where your neighbors on both sides and whatever you're doing is has elements of risks, sure, that exist in your kitchen, but you're adding another one. I mean, you know, one has to, I think, be reasonable about it, either side, either way, and be prepared to ensure that you don't do anything to create a significant risk of harm to your neighbors.
Right.
That's the bottom line.
Right.
Because you are engaging in something that can have that impact.
Yeah.
And so if you want people to support you in terms of accepting cannabis as mainstream, you need to be aware of the people who are complaining about you stinking out their neighborhoods. Not only is it invading your privacy if you're a medical patient and attracting attention, which we thought you didn't want,
right.
But you are interfering with other people's enjoyment of their property. Not everybody enjoys the smell of cannabis.
Right.
Some people find it offensive, and we have to be realistic about that, and be considerate about that, because that's, you know, there may not be statistics, or it may not be hugely statistically significant, but the inspectors around the province that I talk to from time to time in various cases tell me that smell is the main thing that leads them to going and doing an inspection.
Really?
Complaints from neighbors about smell.
Well, and
so that leads to a whole further unroll, you know, so people, Ramo says in his evidence,
can't smell a thing.
You can do something about this.
Yeah.
And
there's techniques there that...
So be diligent and do something about it is my best opinion.
Now the other thing, the other Remo note that was really funny, I thought, was the video they played. Now we all had to sort of gather around the other side of the courtroom to see the video screen, and up comes the world's largest joint, the Remo video, showing him, you know, it's a farcical video showing him rolling a big huge male bud in a newspaper and taping it up with masking tape and then pretending to smoke it. But did the Crown Counsel really believe that this was an actual video showing how Remo uses his medicines as they stated, or was this just
I was unsure at the start. I was unsure. I mean, it was clear to me, and I knew that it was a joke. Yeah. And so I was a bit unsure as we watched it unfold, but they certainly seemed to be.
Remarkable.
The Vancouver Sun wasn't in the room to see that it was their newspaper that was being rolled up.
I tweeted at them with it.
And an old male plant that he out in the back or had forgotten about or whatever. I mean, it was so apparent in
it was
the
ridiculous.
Video. Yeah. But
and you could see that he wasn't smoking it either. I mean, they were holding a joint.
Exactly.
Yeah.
Or something that was creating the smoke.
Yeah.
And so I think, you know, their effort obviously was to show that he's an advocate, that he's, you know, a patient who also is into the community of, you know, he's much more involved in all sorts of ways. And But he did, in his advocacy or his expert witness statement that you're required to file in federal court, he disclosed that. He disclosed, you know, he was aware of that and the rules and so on, and he doesn't for a minute hide or dispute, and didn't in court, all of those things. And so, you know, you have to take into account that he's a person immersed in the whole thing and therefore has considerable expertise, whether you support it or not. And everything he talked about was, you know, equipment and what's available and all these developments that address these concerns about fire, mold, public safety, security devices, all these sorts of things. So, you know, to illustrate that this can be done without all this hyperbole from all of these police and fire chiefs about the dangers. But again, it's people in the community who are doing it, who do have to be diligent and vigilant to ensure that nothing happens. Because anytime anything happens, you can rest assured they'll use it as evidence in the case against us.
No kidding. Now, you mentioned, of course, what the hyperbole of the government's case and the fires and the mold and all this stuff. Of course, that's what their witnesses were here to speak about, or you guys were to cross-examine them about their affidavits on those subjects. And, you know, what it seemed like was when your witnesses were here, they did have a lot of evidence, a lot of things that they were actually pointing to, tangible, real things. It didn't seem like the Corporal Holmquist today and the Health Canada witnesses had as much in terms of actual evidence to point to. You know, it doesn't seem like the government is really able to support this whole fires at medical grows, grow rips, robberies, all of the things that they're actually pointing to that show that operations are a danger, medical grow operations are a danger. I don't know, how do you think that their witnesses were doing? Today, as I said, I thought it was a bloodbath. I mean, they didn't have any evidence to point to. It was anecdotal at best.
Well, I mean, you know, a lot of this evidence was there in support of their case at the time of seeking the injunction, and Justice Manson granted an injunction, and the Court of Appeal, after the government appealed, upheld that injunction. So we've always known that the evidence that they presented didn't warrant or wasn't sufficient to prevent making sure that the people that would suffer irreparable harm on a serious question would be protected in some way. And so that was the whole purpose of the injunction pending trial. So, you know, they've repeated a lot of that evidence, and so what we've attempted to demonstrate for the court is that in our case in chief, there are all these devices and other ways and means of doing everything safely and securely, and that there is a population amongst the patient affected that will not be able to afford the LP prices, and therefore will be put in a position where they will have to choose between their liberty on the one hand and their health on the other, which is the fundamental basic issue that's apparently not being re-argued in this case.
Yeah.
So, you know, then we have to take into account all of this other evidence, and we again say, as we did at the time of the injunction, that, as we pointed out, Health Canada has no records of any of such events or incidents, generally or specifically in relation to any of the patients. They have no such records. And they are the ones who are asserting the problem. But it's clear on their own evidence that they're relying on Corporal Holmquist, Fire Chief Garris, you know, that evidence.
And I mean, Holmquist today was forced to really admit that none of his evidence was statistical. You know, everything that he had said, he basically admitted that it was just his speculations on things, his conclusions.
Well, you know, they've known, as we presented Professor Boyd as our expert in rebuttal to Holmquist and others, but particularly because she wrote a book called Killer Weed, about the media distortion of the whole issue, and how crime and police and so on rely on this. So politicians, you know, it's something those of us who've practiced law for many years and in the courts know from prior research and all the rest of it that most people get their information about criminal justice issues from the media, and more from video or TV type media, the 5-second clips and so on.
Sound bites.
You know, used to still also be the paragraphs in the newspapers, but they're disappearing into a box as well.
Yeah.
So people get that information, they react to it, usually emotionally, usually without stopping to use their heads, and it takes a while often for them to process it and use their heads. And so they're reacting to emotional stories, and that, you know, the advertising industry has figured this out a long time ago, but politicians and government people know how to, and media people further, to you know, use that stuff in a way that impacts public policy to a point where it's hard to imagine anything to do with reason, logic, and rationality.
Right.
So
it's hidden under the emotions of it all.
you know, it's a complicated situation in terms of trying to.
Yeah. Well, those stigmas last. I mean, and they're on everybody too. I mean, you know, if you don't have the information that shows the truth of things, all you really have to go by is what the media tells you.
And so her book basically says that that's what's been done in terms of marijuana. There's lots of evidence, I think, to support that position. They chose not to cross-examine her, and so we say her basic perspective that they were on notice of in terms of our challenging their people was not contradicted. It's unchallenged. It doesn't mean that they can't argue that she shouldn't be accepted, but we argue that that's a factor in our favor. And so I think my submission would be that the cross-examination today showed that, again, it isn't social science research that they have done in order to show what's really going on. It is media stories, police reports, often without knowing what the results were.
Right.
So it is what we call anecdotal. It's not sort of scientific research. And so, again, it has this weakness of people being emotionally affected by the stories and forgetting to put them in perspective in terms of it being less than 2% of the numbers of people involved engaged in this sort of activity. So trying to distort the picture by pointing to a minority of abusers in order to take away the ability of the non-abusers, those who are trying to do it and do it properly and so on, from being able to continue to do so. And so create this difficult situation where, again, it seems clear to us that some people who are medically approved will be forced to choose between their liberty and their health.
And I hope that Justice Phelan isn't suffering from some of those stigmas. He seems to be very aware of what's going on, asking a lot of questions. What your take on Phelan himself and the way he's responding?
Well, you know, he is a judge of the federal court. His reputation is one of an independent, fair judge, and that's all we can hope for. We don't expect him to predetermine the issue. We expect him to hear the evidence, and he'll decide the case according to the rules, and that's what we want, and that's what the Crown or the government, the defendants, want. So, you know, I think we're lucky in Canada to have, again, a constitutional democracy with independent courts where we can come before the federal court and someone like Justice Phelan to decide this case in a peaceful manner, without any violence, without some of the things that we see unfortunately happen in other places, in other countries, over issues.
No kidding. And now, John, when he does make his decision in this case, I mean, whatever happens, whether he decides in your favor or in the government's, this will likely be appealed and move on in some way.
Well, you know, history, who knows?
There's a chance it won't be, of course.
I think it's safe to predict that you could take that position. That would be the normal course.
Right.
But hopefully people will vote for the young Mr. Trudeau, whose father brought us the Canadian Charter of Rights and Freedoms. His Minister of Justice at the time was Jacques Chrétien, who was another Liberal Prime Minister.
Mm-hmm.
And so,
just don't start smoking yet.
Well, I'm just saying that he's the first politician in my time. Lots of them talked about decrim and the ticketing schemes and all these things in the past, and I've seen it come up to the brink on many times in my career. And so here we are again with coming up to an election, and one of the parties has made a clear position on not just decriminalization but legalization. Yeah. And he appears to have informed himself on the topic. He's not shying away from it.
No, just the
even
opposite.
Though, you know, conservatives or so-called conservatives, I don't think progressive conservatives, Joe Clark was in favor of decriminalization, as I recall.
Right.
So
it's a liberty issue for many conservatives.
Exactly. In the old days, I mean, the Diefenbaker Bill of Rights, for goodness sake, you know. I mean, something's changed in terms of these labels. But anyway,
right.
We digress. So, you know, people need to look at that and say, look, we could elect a government that will legalize and regulate and tax cannabis after all these years, as is happening in Washington State, Colorado, Alaska, Oregon, blah, 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 as they roll across the United States. And we can do it on a national level. There's history here in terms of the whole alcohol thing over the years. But here's an opportunity to have that, and it's way more than just enabling people to consume cannabis privately and subject to reasonable rules and regulations, you know, like alcohol or tobacco, whatever. It also is about having the government, the state, interfere less in people's choices of the types of things that they wish to do. Mm-hmm. Again, defining the parameters of aspects of your rights under the Canadian Charter of Rights and Freedoms, to see, you know, so that hopefully people will see that it's more than just being able to engage in the conduct, and that there are limits to these things, and that they'll see that, for example, in relation to other drugs, where people are perhaps addicted, that while nobody wants that to happen, and the perhaps traditional model has been, oh, we need to have offenses and penalties in order to deter them, we know that it's beyond that, that once people are addicted, the whole accepted definition of addiction, even by the federal government in the other PHS case to do with the supervised injection site,
that's right,
you know, understands that that's futile, and that things like supervised injection sites, accepting that these are health issues and not criminal justice issues,
right? Locking people up is to make those problems
is
go
what
away.
Has to happen at the end of the day.
Exactly.
Criminal law should be reserved for serious matters that involve harm to others and significant harm to others.
Right.
It is the big stick, and it should be used reservedly, not just in the naive belief that by simply creating offenses and having penalties and forgetting about the cost of enforcement, you're somehow going to make people change their ways.
Right. They think if they make it harsh enough, they can deter people from doing it at all. But
look at this thing recently. I'm going to have to go pretty quickly, but look at this thing where Mr. Harper's just come out saying that all these certain criminals who've been convicted and who are now serving life sentences are going to have to do 35 years. I don't know all the real details, but one of the more interesting aspects of it too is that the parole board, the Independent Parole Board of Canada, will not be able to make the decision at the end. It's going to be the cabinet, which is a political decision. You know, when you're talking about making individual decisions about liberty and principles of fundamental justice. You don't have politicians make those decisions.
No.
You have judicial or quasi-judicial bodies make these decisions.
It's got to be independent.
And you know, whatever one may say about the parole board and who appoints them and so on and so forth, they are an independent body that comes and looks at these things, and they're subject to a statute, they're subject to rules, they're subject to appeals. There's a whole process there to deal with it, as opposed to this, you know, we are the cabinet, we can do whatever we want type of a thing, and do it in a case where, sure, you know, the public's emotion, again, in relation to these individuals, they're not sympathetic individuals. But the whole point of having the rule of law and having a charter of rights and freedoms is to make sure that it works for the worst guy.
Right.
If it doesn't work for the worst guy, then what's the point of it? Is it just convenience for the non-worst guys? I mean, we prove the value of it by making it apply to the worst guy.
Absolutely. Well, John, thank you so much for talking with me today. Great work.
All right, thank you.